Most estate plans today involve something called a living trust or a revocable living trust, and it's something that comes into effect while you're alive. The living trust talks about how you want your money, property, or other assets used both while you're living and after you pass away. Now, the important thing to remember about a living trust is there are essentially three offices or positions involved. There's the trustor, the person that gives money to the trust, the trustee, the person in charge of managing the property that's held by the trust, and the beneficiary, the person who's benefiting from the money or other property that was put into the trust. Now, while you're living, you'll generally occupy all three of those positions. That is, you're the person who put the money into the trust, you're the trustee, you're in charge of managing your own money, and you're the beneficiary. The trust, while you're alive, is for your benefit. If you become disabled or after you pass away, the trustee changes because at that point you're no longer able to manage your money or property. And after you pass away, obviously the money that's held in the trust is for your beneficiaries. So it's important to remember that the different offices change based on where you are in your life. The one that doesn't change is trustor. You're always going to be the trustor of your trust because you were the one who put the property into the trust. Now, why would you use a living trust or a revocable living trust rather than just a will? Because you're saying, well, they do essentially the same thing. The main reason is that in California, there's a process called probate. And if you die with just a will, or if you die without a will and no other devices such as a living trust, you have to go through a process called probate. And it's very expensive and takes a really long time. So most estate plans today utilize a living trust or a revocable living trust to avoid that. I'll talk a little bit in another video about what probate is, but it's, in short, a court-supervised administration of your estate, meaning the courts are involved in making sure that all the things that you've specified in your will are carried out. A trust doesn't have that because the trust is a document that describes what needs to happen and the trustee is responsible for making sure it happens.